Hello everyone, I extend a warm welcome to all the students watching today's lecture. This is part 2 of my lecture on types of companies. In this I shall be discussing about what a public company is and about conversion of a public company into a private company. Now you are already aware what a private company is and what a company having limited liability and company having unlimited liability and a company limited by shares, company limited by guarantee, that we have already discussed. Now today I will be telling you about what a public company is. As per section 2 subsection 71 of the Companies Act, a public company means a company which is not a private company and which has a minimum paid up capital as may be prescribed. So, which is not a private company means a company which invites public to subscribe to its shares and debentures, in which there is no restriction on the number of members and in which there is no restriction on the free transferability of shares among the members of the company with outsiders and also among the members. So, and also it has a minimum paid up share capital as may be prescribed. Presently there is no minimum which has been prescribed. Earlier there was a minimum, but now public companies, just like private companies, can start without any minimum capital requirement. Any amount of capital, with any amount of capital, at least 7 people, which is the minimum requirement of number of members, can start a public company. Provided that the company which is a subsidiary of a company, not being a private company, shall be deemed to be a public company. So, every subsidiary of a public company will be called a public company itself, even though that company by its articles is not a public company, is a private company, but still if it is a subsidiary of a public company, it will deemed to be a public company. And the name of the public company has to end with the word limited. In short, it can be written as LTD and a dot. This is how a name of a public company should end. Now, after the definition of a public company, then we move on to the conversion of a public company into a private company. See, a public company can be converted into a private company, and also a private company can be converted into a public company. The conversion of public company into a private company is a bit long, involves more formalities than the conversion of a private company into a public company. Why the conversion of public company into a private company involves more formalities is that public company is a company which is in public domain. It has many stakeholders. So, if such a company wants to go into and become private, it will have to have the consent of all its stakeholders, take permissions from various authorities, only then it will be allowed to become a private company. So, there are various steps which have to be followed only then a public company can become a private company. The first step is that the board of directors have to convene their own meeting after giving at least 7 days notice. So, the board of directors have to first of all call their own meeting and have to decide in their own meeting whether they want to convert their company into a private company or not. And for calling that meeting, they have to give at least 7 days notice to all the board of directors, all the members, all the board of directors and all the directors, and then after the meeting is held, they will decide upon, and if they approve of such a conversion, then next step is that they will decide on the date, time, venue of the general body meeting of the shareholders. Why general body meeting of the shareholders? Because that is the next step. After the board of directors have approved of the conversion, it moves on to the shareholders and a meeting is to be called, and in that meeting the shareholders have to approve of that conversion. So, the notice for that meeting of shareholders has to be at least 21 clear days notice, and the notice has to be given to every shareholder, every auditor, every director, etc., along with the explanatory statement for the proposed special resolution, meaning thereby that at least 21 days before the meeting the shareholders and auditors have to be informed. 21 clear days notice means the day on which the notice is posted or dropped. If it's email, the day on which the email is dropped, and the day on which the meeting is to be held, those 2 days are not counted. In between there have to be 21 days. This is the meaning of 21 clear days notice. So the notice has to be of 21 clear days. Now why the notice of 21 clear days is to be given? Notice of 21 clear days is to be given so that everybody is able to know, everybody has enough time. There are so many shareholders of companies, they must be residing at different places, especially when it is a public company, it has numerous shareholders. Everybody has to plan if he or she has to come for the meetings. Therefore, a proper notice has to go. And along with this, that particular notice, explanatory statement is also to be attached. Explanatory statement has to be attached with every notice of the meeting for any item in which special resolution is to be passed. So, explanatory statement will give details about what is the issue, why the company wants to convert into a private company, and the various relevant information. Basically, the reason why explanatory statement is attached to the notice is that the shareholders are aware what is to be decided about. They take an informed decision. That is why explanatory statements are attached to the notices for the meeting. Then the next is that shareholders meeting is held and a special resolution is passed. Special resolution, for those who are not aware, special resolution is a resolution wherein decision is taken by 3/4 majority. That means at least 3/4 of the members present there must vote in favor of the resolution, then only that resolution will be passed as a special resolution. So, if at least 3/4 of the members present at the meeting vote in favor that the company should be converted into private company, then only that particular resolution will be passed. And once the resolution is passed, then the word private will be added to the name of that particular company, and also the restrictions which are there for a private company, which the private company puts in its articles of association, will be incorporated in the articles of association of this particular public company. Only then it will be converted into it can be converted into a private company. And those restrictions are, what are the restrictions? The restrictions are that the company will restrict the free transferability of shares, the company will limit the number of members to 200, the company will prohibit people from subscribing, general public to subscribe to its shares and debentures. These are the restrictions which a private company has, and if this public company wants to convert into a private company, it has to include these restrictions in its articles of association. Now, the next step is filing MGT 14 with Registrar of Company. ROC is the Registrar of Companies within 30 days of passing of special resolution. See, basically what MGT 14 is MGT 14 is a form which has to be filed by the company at a portal of Ministry of Corporate Affairs. There are various forms which are under various names which have to be filed by the company for various purposes. So, this MGT form 14 form is for filing certain resolutions with the Registrar of Companies, and MGT here stands for management. So, in MGT form, a copy of the resolution has to be filed within 30 days of passing the special resolution, along with certain other documents also, along with notice of calling of meeting, a copy of special resolution, altered articles of association and memorandum of association. All these things, altered articles are also to be filed along with MGT 14, altered memorandum of association has also to be filed along with MGT 14. So, these things have to be filed. Then the next is, in case of public company is listed on a stock exchange, it has to get itself delisted by following the delisting provisions prescribed by SEBI. And of course, since it is going to be converted into a private company is not allowed to be listed on a stock exchange, since there is a prohibition on its shares being traded freely. Therefore, if the shares of this particular public company are listed on the stock exchange, they have to be delisted from there. Then the next is taking approval of the central government. Now, approval of the central government is also to be taken. The approval of the central government comes through the regional director. So, applying to the concerned regional director in form RD1 within 60 days of passing a special resolution by the company is the next step. And along with the form RD1, certain other documents have to be filed with the regional director. What documents? A copy of board of directors resolution authorizing conversion, that is to be filed. Then minutes of the meeting wherein the special resolution has been passed, that is also to be filed. Then copy of altered memorandum and articles of association, that is also to be filed along with the form RD1. Then declaration of key managerial personnel that the company limits the number of members to 200, and also stating that no deposit has been accepted by the company in violation of the act. So, there is another declaration which is to be made by key managerial personnel of the company. Key managerial personnel means the chief CEO of the company, the managing director of the company. So, these key managerial people have to make this declaration that the number of members will be limited to 200. That is a must. And if the company does not have any key managerial personnel, then in that case directors will make this declaration. Then the next step is application should also state the reason for conversion, details of conversion made during the last 5 years, and whether the company is a Section 8 company or not. So, this application in RD1 must also state the reason why the company wants to convert, and whether there have been any conversions in the last 5 years, and whether it is a Section 8 company or not. Section 8 company is a company which is association not for profit making. So, it has to be declared whether it is a Section 8 company or not a Section 8 company. Then along with this application, a list of creditors and debenture holders of the company is also to be attached, giving details how much amount is due to these creditors and debenture holders. Then it is also to be accompanied by an affidavit signed by the company secretary and 2 directors of the company, one of whom shall be a managing director, and that affidavit should state that they have made full inquiry into the affairs of the company and are of the opinion that the list of creditors along with the amount stated is correct. So, that is another requirement. Then the next is that the company should advertise in the form number INC 25A. Now, this advertisement is also to be made in this particular form at least 21 days before filing of the application. So, advertisement is not to go now when the application is being filed in RD1, it has to go at least 21 days before the filing. And where this advertisement is to be given, it is to be given in 2 newspapers. One is of some local language of that area, vernacular language, which is this is how it is called, and one in an English newspaper, and also it is to be put on the website of the company. And a statement to the effect that any person opposing to the application for conversion can file his objection to the concerned regional director. So, the whole purpose of this advertisement is that anybody who has a notice of it, and if anybody has any objection to the company being converted into a private company, can file his objection to the regional director. Then the next step is that the company should serve by registered post individual notices to whom? To each creditor, to each debenture holder, as well as to the central government, to regional director, registrar of companies, SEBI. All these authorities and all these individuals have to be served a notice by registered post about the proposed change, at least 21 days before the date of the application. So, all these people have to be in fact posted letters individually stating that the company wants to convert into a private company, so that if any of these authorities or any of these individuals, creditors, debenture holders has any objection, that particular person can reach the regional director along with his objections, so that it can be addressed. Now, once all this is done, there are two situations. First is when no objection is received from anybody, and the second is when some objection is received. So, where no objection has been received from any person in the response to the advertisement or to the notice, and the application is complete in all the respects, then the concerned regional director shall pass an order approving the application within 30 days of the receipt of the application. So, if everything is okay, no objection is received, then the regional director will give an approval and the company will be changed from a public company to a private company within 30 days of the receipt of the application. Then the next, in case there is any defect in the application or some information is not provided, then the regional director will ask for company to rectify the defect within the next 15 days. And the company will have to then make another submission rectifying the defect. Maximum 2 resubmissions are allowed. Beyond that, the application will not be considered, will be cancelled, and the company has to make a fresh application. Now, in case the company does not rectify the defect or no information is received from the company, then the regional director will reject the application within 30 days from the date of filing. So, even if the company rectifies the defects and submits an application, if the regional director is not satisfied, it will reject. If the company does not submit any information, then also the regional director will reject the application. Now, the second situation, in case some objection is received from any party, maybe some creditor, maybe some debenture holder, maybe some other government authority, then in that case, regional director will arrange for hearing and would ask the company to file an affidavit to record consensus. The regional director will then pass the order either approving or rejecting the application within 30 days. So, hearing will be arranged, then the regional director will ask the company to file an affidavit as regard the consensus which has been reached. Suppose after the hearing some consensus is reached between the creditors and the company, or if the aggrieved party is or the objecting party is some debenture holder, between the debenture holder and the company. So, that consensus has to be recorded and has to be filed as an affidavit with the regional director, and the regional director will then pass an order approving or rejecting the application within 30 days from the hearing. Now, in case no consensus is reached, the regional director may still approve conversion. It is not that the regional director will straight away disapprove, he can still approve the conversion if it is satisfied that the conversion would not be against the interest of the company. The conversion can still happen even if the objection has been received and people have not been able to reach to any consensus, still it can be approved. Then the conversion shall not be allowed if such a conversion but shall not be allowed if an inquiry, some inspection, some investigation has been initiated against the company, or any prosecution is pending against the company under the Act. In that case, for such a company, it will not be allowed to convert itself from a public company to a private company. Now, the order conveyed by the regional director shall be filed by the company with the registrar of companies in form INC 28. So, this order of approval of conversion shall be filed by the company with the registrar also of the company in form INC 28. Now, this form INC 28 is a form which is to be filed by the company at the portal of Ministry of Corporate Affairs, and this form is specifically for the companies, for all the public companies who want to get themselves converted into private companies. It is meant for them. Now, within 15 days of the date of receipt of approval of the regional director, this INC 21 form has to be filed with the registrar of companies by the company concerned. Then within 30 days of filing of form number INC 28, the registrar shall close the former registration and issue a fresh certificate of incorporation if it is satisfied that all the requirements have been complied with. So, finally, within 30 days of filing of the form number INC 28, the registrar shall close the former registration and shall issue a fresh certificate of incorporation if it is satisfied that all the requirements have been met, and finally the company will be converted into a private company from a public company. So, these were the steps which were required for the conversion of a public company into a private company, and the entire procedure is of course a very long one, since as you can see there are so many stakeholders which are involved, and so many authorities from where the approval has to be taken, so many people who have to approve of it. That is why it is a long procedure. But as compared to this, the procedure of conversion of a private company into a public company is comparatively shorter, and which will be we shall be taking up in our other parts of this lecture which will follow. So, for today this is all I have. Thank you all of you. Keep reading, keep learning. Thanks a lot.